Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson.
Hi, everybody, and welcome to the July 2024 edition of the Third Fridays podcast. The year is more than halfway over. Surprisingly, we're in the thick of summer, so I hope you're avoiding those heat waves. But today I have an interesting topic for everybody. COVID-19 claims, they're still here. They won't go away, even though no one can actually prove that they got COVID-19 from a particular employment event. They are still here. Employers across the state are getting punished for, what appears to be a misapplication of a global event in our world. But in any event, I think that a good person to bring on was an attorney in our office who had secured a disallowance of a COVID-19 death claim in the past year. So he does have some experience with litigating these matters. So welcome back to the show, Tim Kane.
Thank you.
I guess we should just start off with COVID-19 claims, right? When they first came to our desks in, I would say, summer of 2020, right? What was your overall understanding or feedback that you were thinking of when this was changing our world like 4 years ago?
Right. At the start, we were all looking at prior case law, as you do, right? And it seemed to me that in most of the cases that had been established for respiratory illnesses or whatever, you really had to have a specific event, right? So you have a nurse who is with an infected patient, and the patient coughs right in the nurse's face, right? That kind of thing. Or a prison guard who is working with an inmate who's got some disease and they're in very close quarters on a daily basis, just the two of them. And, there's a pretty clear exposure, or, some case, I think a malaria case where someone got bit by a bug, but like a specific event.
Right. In those prior respiratory cases, there was no instance of almost an admission by the medical experts of, I don't know where they could have gotten it, and then sufficient production of proof of, well, it could be at the employer's location, right?
Yeah, I mean, it seems to me it was an idea that if the person could have caught the disease from the general public, that it's not correct to pin it on the employer, right? That's how it seems like it was in the past. So that's why it seemed like you needed, a catastrophic event that was specific in space and time. So someone, sounds crazy, but someone coughs in your face, right? Oh my gosh, they were sick, now I'm sick, and I can pretty clearly point to when it happened.
And when by pretty clearly, right, like there's documentation of that. Both parties agree that this event happened, right? That, and then that this, the person who had coughed did have the illness, right? So when you say like clearly all the facts are lining up for a reasonable person to be like, okay, that's like where you got it.
Right. And per my review, most of these illnesses were very specific illnesses. It wasn't like a cold, right? It wasn't something that was going all around with everybody at the time. It's some, particular illness. So it seemed like at that point in time, the board and the courts were drawing a line in terms of like, hey, we're not just going to establish a claim for the common cold, even though like people probably do catch it at work.
Yeah.
right. Fairly regularly.
Because also, what is the liability? Like, do you want me to pay for your tissues? Do you want some Tylenol?
Right. If it wasn't something that, if it wasn't something that required medical treatment, which, is the kind of thing that would lead a nurse to have their face coughed in because the person was there getting medical treatment, right? So if it was something that anyone in the general public could pass to anyone at any time, it was a common sort of thing, then it wasn't going to be a comp claim.
Right. So, I did preface you coming onto the show with this this allowance that you secured recently. In your case, we had an employee working at a retail store in Manhattan had unfortunately passed away due to COVID-19, and a lot of the decision from the board came down to really like the evidence that was produced by both sides. From what you remember of it, can you give our listeners some type of overview of how that case came to be? Maybe in terms of what did you start thinking of in relation to COVID-19 claims in general, applying it to this really tough case, and ultimately what led to the victory on behalf of the employer?
Well, by that time, it was pretty clear the board, at least on the board level, the trial level, was starting to establish these claims, and they weren't going to follow the prior logic. Despite that this was prevalent in the general community, they were definitely starting to establish COVID claims. So a big part of it was a fact investigation, right? Speaking to the decedent's manager and getting as much information in terms of, whether there were any coworkers who had gotten ill around the same time, what shift the decedent was working on, whether she had any exposure to the general public, because a big issue with a lot of these claims is if there were no coworkers who were ill, if the claimant has, or the decedent in this case, has contact with the general public, that could definitely put them at risk. In terms of the way the board is handling these cases, that could be enough to establish it. So a lot of interviews with managers and potential witnesses, trying to get your facts straight, trying to figure out who's going to be the best witness to produce at trial. A lot of work on figuring out effective cross-examination of the claimant, who was the decedent's husband. So it's really a lot of legwork leading up to trial in terms of gathering up all the facts that you can and drafting the best cross-examination that you can. Yeah,
and did you think that you were almost being forced to prove a negative, right? So when you talk about being public-facing as part of this person's job duties, did you feel like you had to actually retrace their steps and show how much they did not interact with the public in order to get a win?
Absolutely. So this individual worked at a department store, and so there's definitely the opportunity for exposure to the public. But it was a big department store, and they had employee elevators, they had public elevators for the customers to use. Sometimes employees would use the customer elevators. Things like that. They also had locker rooms for the employees, so they might interact with other people who are not part of their own team, right? So even if they're not public facing, they could go in the locker room and potentially interact with a coworker who faced the public. So there was definitely a lot of retracing steps. There's also a question of how this person got to work, and whether there was going to be an argument by the claimant side that the commute should be somehow included in the exposure, right? But it turns out that in this particular case, she was dropped off every day by her husband per his testimony. So we got rid of that potential vector of exposure. But yeah, there was a lot of pondering, how could this have happened, and where she was in the building at any given time.
Yeah, it just, because it seems like any person can say, well, we could use this method of facing the general public. And in fact, maybe I did face the general public in my job. I can really actually think of many, many jobs in the workplace across the state where, in theory, you could become in contact within 6 feet, not wearing a mask, of someone else that could be either a customer of your business or someone that is just around your environment in the course of you performing work for your business. So, when we secured that win mostly by, like you said, like just the legwork and placing her in her normal day, I think that really swayed the court to find in favor of our retail client, which kind of leads us into this case that we're talking about today. It's the matter of Town of Fishkill. It's a board panel decision that came out a few months ago, and it was recently amended for an ancillary issue this past month, because the board panel in this case seems to attribute it to a case where they have found COVID-19 to be compensable. But on the surface, there are a lot of like these little facts that don't really feel like they're applicable to me. So we'll go through it. And, I think that the first thing I'd want to start with is that the claimant in this board panel case, right, he's disclosing a prior COVID-19 diagnosis in 2021, about 1 year before his claim for COVID-19 at the workplace. And he is a law enforcement officer. And I think maybe the reason why that's important is if that COVID-19 positive test in 2021 is not being filed as a claim against the employer, how are we able to assume that that's not related to employment, but this one is, right? So he has a COVID-19 positive test in 2022, files the claim. He has a positive 2021 COVID-19 test, doesn't file the claim. So from a judicial perspective, I mean, I don't think that they mentioned anything about that prior COVID positive test. Does that even matter then?
Well, I mean, they mention it. They don't do much other than mention it. Assuming he had the same employment at the time, I mean, I guess he could have potentially filed a claim at that time, but I guess maybe he just didn't feel like it was a work exposure the first time, right? Maybe
that's the key, right? He didn't feel like it, right?
And this time he felt like it was.
This time he felt like it. Okay. So, and the next part of it, I believe, goes to the heart of why COVID-19 claims are still here today, right? So about 10, 12 days after the 2022 positive COVID-19 test, he goes to get treatment, and he was complaining of back pain. He says that I've had back pain for the past week after my COVID-19 test, and specifically I was coughing and felt a pull in my lower back. And, when we go back to COVID-19, not to disparage or really turn people away from thinking that COVID-19 was did not have severe implications for some people. But this is why I believe COVID-19 claims were so dangerous 4 years ago and that they still exist today, is that you have a claim not just for, however many days or weeks it takes you to get back from positive to negative and be fine. You're going to now add consequential injuries that have substantially more exposure just because you're making this tangential connection between COVID-19 and any body part you want, or any condition or any type of systemic issue that probably has some unrelated cause. But I mean, this mechanism is so striking. It's not, you think of a consequential back claim to a COVID being like, after receiving my positive test, I drove to work and I got a motor vehicle accident. Right? What's your view of this consequential back injury being raised by the claimant here?
It's interesting. It's to me, it's kind of seems like, again, in the past, it's before COVID-19, the board was Again, really not interested in establishing claims for things like, a cold that, could be caught at work, but it's like, okay, this is just something that happens to everybody, and, you just have to deal with it. Right. So in this case, he had a cough, Of course, I guess he did have COVID. I guess that was objectively proven with the test, but can we say that cough was a COVID cough? Maybe he was just clearing his throat. Like, it's a little weird. So, everybody coughs from time to time.
You could have COVID-19 and have a cough for any number of reasons.
Right. Any given cough could be for any reason. Like, so it's weird from the perspective of a defense attorney. Your immediate thought is that an orthopedic injury, a back claim, a classifiable injury, completely changed the exposure picture of a case like this. So you want to do everything you can to keep it out. Obviously, effective cross-examination of the claimant's doctor. I feel like it would be very hard for the doctor to prove, like, yep, he coughed and now he's got because nobody gets a back injury. Well, some people do, but right, as soon as you see back injury, you're thinking this person is going to go out of work, get classified, so
right.
It's a big red flag from a defense perspective for sure. And it's the kind of thing where you want to roll your eyes at it, but then that your client is going to be facing serious exposure, and the board is going to take that claim seriously, so you have to as well. So,
and yeah, again, it's like why we're here, and you say, as the defense attorney, you'd kind of dig in, and it seemed at this point that they really were, they elicited testimony from the claimant where he denied knowing of any coworkers who had recently tested positive. He also ran a particular program for the department, and he knew of no participant who had tested positive. And all of the things that he was talking about in terms of his day, it results in, the trial judge disallowing the claim, where the defense says it should be disallowed, but in the alternative, there should be a finding of dual employment since the claimant was exposed to the public in two particular jobs. So we were talking about a little bit about this before we went on air, and maybe we disagree, or it's like a term of it's a concept of strategy where the defense attorney and defense attorney does his or her job at this point because they got the disallowance at the trial level, says, I want you to say that the employer and carrier has no liability for this COVID claim, but then also saying, but if you do, don't put it all on me, put it on his other employer. I was taking the position that I wouldn't want to give the law judge an out to not give me the most prioritized application for relief. You were taking a slightly different position in terms of the protection of the client in the event that we didn't get the first win, right? Can you talk a little bit about that in terms of the strategy?
Yeah, sure. I know that what you're suggesting, you wouldn't leave that other argument on the table. Ultimately, you would say it. It's really more of a question of how do you characterize it to the judge.
Right. It's going to be when that argument comes, right? So if I say I'm not omitting that alternative argument completely, I'm just not saying it first. I'm not giving the judge an option. I'm saying your option is either win or lose, and then I'm going to make the argument, where you want to make the alternative argument in the summation sometimes,
right?
Because that alternative argument is still better than the worst case scenario.
Right. So sometimes you'll have one and sometimes two or three alternative arguments, and it's kind of like a decision tree situation where, like you said, you've got your top priority application for relief, and then you've got others that are not as good, but they'll still mitigate exposure for the client. And I think that it really comes down to the feel that you have for this particular judge and how things are going. If the judge has given you some clues that they're probably going to disallow it, you might just do it the way that you're suggesting. But at the same time, the board can be a little bit weird, or the board panel too, about the timing of certain applications. So if the if you ask for a disallowance and the judge said, no, I'm going to establish it against your insured, and then you bring up dual employment, they might say, well, it's too late. So it's
Right.
it's a little bit of a question of feel, what the vibe is that you're getting when you're litigating things. But for example, if it's a situation where you do a written summation before you go to court, which kind of depends on where you're at in terms of development of the record. But if you have a fully developed record and you put a written summation in the file, you're going to, I would suspect you're going to make all your alternative arguments in that summation. So I don't want to be in a situation where the board panel comes back and says that, the second or third alternative argument were not, timely made.
Yeah, that's actually a great point with the summation brief. And because now what we're doing is we're really talking about things other than COVID-19, just the process, like the technical nuts and bolts of being an attorney here, which is kind of nerdy, but that's just up my alley anyway. We have a situation here where you're saying if you file the summation brief and you have the alternative arguments in there, right, you're more likely to just kind of include everything. Do you think that by having a summation brief with your best argument and then your alternative arguments laid out, that you can go into oral argument and just give the high priority argument because you know that you have completed the record with those alternative arguments in writing? Or does the summation brief make you think I have to just restate everything orally with the alternative argument?
No, actually, that's a really good point. If you've got them all already filed, right, you can tell the judge that, for the most part, I'm going to rest on my formal written summation.
Right, you reiterate, reference it,
and then you can really swing for the fences, and you can say your one big application. I'd like a disallowance here, right? That's a big one. So you can say that, and then you could just reference your written summations, what you've presumably already referenced, but you can say, and I've got a bunch of alternative arguments as well, per my summations. So without going into great detail about the alternative arguments, because you already have them entered onto the record, you can make that big swing for the fences.
And I guess to come back then to this case, the board panel reverses the finding of COVID-19 being disallowed, and they apply, a different workers' compensation claim where the claimant's general work duties as a police officer, including patrols, traffic stops, responding to 911 calls, and then my favorite, generally enforcing the law, right, results in a compensable COVID-19 claim. Here it's interesting that they cite a specific paragraph from that case in 2023 where it says, while it may be impossible to determine exactly when or where the claimant's infection with COVID-19 occurred, this does not preclude a finding that an accident occurred in the course of employment. And this kind of ties back to what you were saying in the beginning of your initial thought process when it came to COVID-19 claims in general. If you looked at older respiratory disease claims, you were able to pinpoint, exactly what happened, right? Nurse coughs on someone, prison ward or prison guard deals with an unruly and sick inmate in the infirmary or something like that. And they're just basically saying none of that really matters, because even though you can't determine when something happened, if you can produce testimony, i.e. self-serving claimant testimony, that there was this general function of having a connection to the public or, being public facing, that it then becomes possible for the COVID-19 claim to be compensable. I just don't know how that claim gets reversed without saying what the trial judge did was incorrect, right? It's almost like they're making findings of fact in this board panel decision without referring to whether or not the law judge had, was within his discretion to find that the claim should be disallowed.
Right. Yeah. They're just. It seems to me perhaps they know where they want to get to, right? And so they're just finding a way to get there. But for me, it's very worrisome because, again, people catch colds from the general public, and so a public-facing employee could catch a cold. You can just as easily cough when you have a cold and you've got a back claim off. So this, in my view, potentially opens the door for, it seems like, COVID-19 was obviously a very well-known illness in recent years, but it does kind of leave the door open for a lot more types of common illnesses to come into, what we deal with on a regular basis. And it's tough because, again, if someone's got tuberculosis and they're in a hospital bed and they cough on a nurse, you get that. But this is, I could analogize it a little bit to World Trade Center claims. I mean, those are very sympathetic types of, claimant witnesses, and if you and it's very hard to find it's very difficult to find evidence to the contrary in terms of something that happened at this point over 20 years ago. So like similar to this is a cop who does deal with the public, got COVID-19. You don't have evidence that they didn't get it on the job, which is, like you were saying earlier, like proving a negative is just nearly impossible. Obviously, you can't go back in time and surveil this claimant at all times and say, someone coughed near him when he was off duty. Like, it's just, so it becomes extremely difficult in terms of facts. And
right, like you have to be sure. Like, I found you at an amusement park talking to so-and-so within 3 feet unmasked, and that person did have COVID, right? Like, you're basically being Sherlock Holmes, right? And because the board panel is saying, the board panel can identify no evidence in the record to support a non-work source for the illness. That's not what they're supposed to be doing. It's supposed to be the claimant supposed to be supporting a work source for the illness, right? And not the proving of a negative. But in any event, the board panel closes that analysis with a few sentences saying that the employers failed to rebut the presumption with the requisite substantial evidence, despite the fact that they reference testimony from the claimant indicating no knowledge of anybody else becoming positive. So that is very troublesome. And then when we get to this consequential back injury, it's being remanded for that aspect, because now that you have a compensable COVID-19 claim, you're opening the door to these consequential injuries, and the board panel sentences it back and has a little bit of note at the end where it says, ultimately, the claimant underwent thoracic spine surgery on March 8th, 2023. So while this case was pending on compensability, the claimant goes and obtains surgery just without any other facts, because we can litigate, like, what are the supporting facts that led to this? Do you think that makes the consequential back injury more likely to be compensable or less likely to be compensable?
And just based on experience, I think the fact of the surgery does make it more likely that it's going to get established.
Right, almost that that World Trade Center analogy you brought up, right? Like, you become a more sympathetic claimant. Like, oh, you must have really needed this surgery.
Right.
You were willing to undergo it while the compensability of your case was on appeal. So again, right, shedding light on how important this case is. We're wishing good luck to the employer in that remand case. So are employers really just out of luck? With a claimant who goes to a doctor and says, I coughed after my COVID-19 test that was positive, and I felt a pull in my back. Like, I'm not making a work claim, but, as I sit here in a chair, like, I'm not 22 anymore. Like, I sometimes I feel a pull in my back just based on the way it rotates, or if I'm slouching, sitting up straight, like if I'm, what are employers going to do if this is the possibility of this far-reaching, COVID-19 claim?
Well, I think that effective cross-examination by people like us is probably their best bet. You want to get as much information as you can as well about this person's medical history, whether they had any prior motor vehicle accidents. I'm pretty sure the diagnostics in this case indicated degenerative conditions and not acute conditions. So these are the kind of things you'd want to ask the doctor about. I sense that unless this is like a real comp regular, like I think most doctors would be hesitant to say that the cough caused the back injury when it comes down to it, right? When it's one thing to put it on a sheet of paper, and it's another thing when they have to give sworn testimony.
Right, right. Especially because most of those sheets of paper are not even really completed by them. It's like a form completed by their staff,
Right.
dictated, and just I won't get into that soapbox, but you're right. I mean, getting that doctor on the stand, which potentially also means waiving an IME, right? I mean, the IME fines, if you get an IME with a claimant who already had back surgery, unless you're going to prove that negative, an IME concedes causal relationship, you might not get to cross-examine that doctor. So if the takeaway really is to focus on your cross-examination here, I hope this employer is really thinking about, the circumstances that lead you to still retain that right? Like avoiding some risk in that scenario. Not to say that you can't cross-examine an expert witness with an IME report, but it is a little bit harder to do, practically speaking.
Yeah, it's a strategy decision, right? Do you get that IME or not? It's a worthwhile conversation.
Yeah, so I think we'll end there, because the idea here is that COVID-19, most people that are listening to us now, although they understand really a lot of the dire circumstances one person can be in from a COVID-19 test, for the most part, right, if we're just restricting COVID-19 liability to the treatment of it, and we can prove that there's a readily compensable COVID-19 claim because, nurse gets coughed on by a sick patient who has COVID-19, right? If we can make that connection, fine. But the advocacy for requesting litigation in these claims is really to prevent this type of scenario where a COVID-19 claim becomes a consequential back injury because the claimant coughed and felt a pull in his back. And I don't know, but I would be harking back on that mechanism every single time I'm talking about this case to a judge. But I think that it's really unfortunate, but this is the world we live in, and you now need to fight it from the perspective of this claimant truly had COVID-19 given to him by his employer. So what's next? Well, we wish defense counsel and this employer the best of luck. So for Tim Kane, my name is Christian Cisan, reminding you to defend from day one.